All right, another new law in California I want to talk to you about. It's called AB 3234. We talked about AB 1950, which reduces the probation times on misdemeanors and felonies. This particular law is only about misdemeanors, and it's very powerful. It's like getting a banana split for you if you're a defendant in a misdemeanor case. The judge has the power now under AB 3234 to completely just dismiss your case. It's called diversion, and it's codified in Penal Code Section 1001.95, which says a judge in the Superior Court in which a misdemeanor is being prosecuted may, at the judge's discretion and over the objection of a prosecuting attorney, offer diversion to a defendant pursuant to these provisions. This is effective January 1st, 2021, so it's a new law. What does diversion mean? Diversion just means that the judge can postpone the case and then dismiss it and have you do some things in the interim, for example, doing community labor, community service, doing counseling or rehabilitation, whatever the judge really wants you to do. The judge could say, hey, do these things and I'll dismiss your case. That's diversion. And it's informal diversion as opposed to formal diversion is when you enter a guilty plea or a no contest plea. No contest is the same thing as guilty. And then you do certain things, and then later on you come back to court, the court withdraws your plea and dismisses it. This is much better. The words guilty and no contest never leave your mouth. That means for immigration purposes, especially people who aren't citizens, it's much better because sometimes even if your case is withdrawn after you say guilty, it's still not good for immigration purposes. Now, I told you this is like a banana split. Well, there's even a cherry on top. What's that cherry? That cherry is that your arrest record is essentially basically eliminated once your case is dismissed. That means if you apply for a job or you go to school or whatever it is that asks you if you've ever been arrested, you could say no based on this crime. You could say that you have not been arrested and it's totally legal. There's one exception, that's if you're applying to be a police officer. Now, let's say you fail. The judge says, okay, go do 10 days of community service and 20 days of counseling, and then I'll dismiss your case. Let's say you don't end up doing it. Well, you haven't entered a guilty plea, so you could still fight your case after that and go to trial and get a not guilty. Now, this AB 3234 applies to almost all misdemeanors. There's a few exceptions. They're the usual suspects. One, domestic violence pursuant to 273.5 or 243E. Misdemeanors that require sexual registration, such as sexual battery under 243.4. And three, another usual suspect that's excluded is stalking under Penal Code Section 646.9. One usual suspect is not excluded, and that's DUI cases, which are usually excluded from exceptions like this. But in this case, your DUI can be dismissed pursuant to this law. Now, there's a lot of people that are very mad about that. One of them in particular is MAD, Mothers Against Drunk Driving. They do not want this to be an exclusion, and I think the governor is thinking about removing it at his first opportunity. How can you take advantage of this law? Well, this is where a good attorney that can present a three-dimensional picture, multifaceted picture of who you are, your background, your history, the unusual circumstances that led to this case, who can really humanize you and make the judge feel you. Do you feel me? Because if an attorney can do that, then you're likely to get your case diverted and dismissed. It's really up to the judge. The judge has a lot of power. Time to get out of jail for free, get your banana split with the cherry on top.